Hello everyone. Today I'll be discussing again a special kind of contract of guarantee with you. As you can see, the literal meaning guarantee. So it's regarding a particular guarantee. This particular contract has been given under section 126 of Indian Contract Act. A contract of guarantee is a contract to perform the promise or to discharge the liabilities of a third person in case of his default. The person who gives the guarantee is called the surety. The person in respect of whose default the guarantee is given is called the principal debtor, and the person to whom the guarantee is given is called the creditor. A guarantee may be either oral or written. So there are three parties basically in this contract of guarantee. The person who can make the default is called the principal debtor. The person who provides the guarantee is called the surety, and to whom the guarantee is provided is called the creditor. Take for example, A promises to a shopkeeper C that A will pay for the items being bought by B if B does not pay. This is a contract of guarantee. In case if B fails to pay C, can sue A to recover the balance. Means इस particular example में क्या हो रहा है, अब A ने promise किया है shopkeeper C को कि A जो भी आइटम्स बी खरीदेगा उसका पेमेंट करेगा. कब करेगा? अगर बी उसका पेमेंट नहीं करता है तो दैट्स व्हाई इट इज कॉल्ड अ कॉन्ट्रैक्ट ऑफ गारंटी. So A is the guarantor or the surety over here, B is the principal debtor and C is the creditor. If B makes a default, means the principal debtor makes a default in the making of the payment to the shopkeeper, then the surety will make the payment and will discharge the liability. That's why in the very beginning discharge the liability of a third person is given in the section of 126. Nextly, in this contract of guarantee, first and foremost essential ingredient is to perform the promise. Second is to discharge the liability, and the liability is of a third person in case the third person makes a default. So in case a third person makes a default, clarifies one important thing, that is that surety is having a secondary liability. When the surety's liability will come into picture? Only if the principal debtor will make a default in making the payment. Next, parties to the contract of guarantee. So there are three parties. The person who gives the guarantee is called the surety. The person in respect of whom the default the guarantee is given is called the principal debtor, and the person to whom the guarantee is given is called the creditor. Next, going forward, let's look at the essential elements of the contract of guarantee. So first and foremost thing, that it should have all the essential elements of a valid contract given under section 10 of the Indian Contract Act 1872. But it has two exceptions. Consideration received by the principal debtor is a sufficient consideration to the surety for giving the guarantee. Second, even if principal debtor is incompetent to contract, the guarantee is valid. But if the surety is incompetent to contract, then the guarantee is void. Primary liability of some person. The principal debtor is the person who can be held as a primary liable person in the contract of guarantee. The contract must be conditional. The liability of surety is secondary and conditional. Why it is secondary? Because first liability is on whom? First liability is on the principal debtor. Why it is conditional? It is conditional because if principal debtor will make a default, then only this liability of surety will come into picture. That's why it is called conditional. The liability of surety arises only if the principal debtor makes a default. Then the second last is no misrepresentation. The creditor should disclose all the facts which are likely to affect the surety's liability. There must not be any concealment of facts. Means the creditor is under a liability to disclose each and every fact regarding the contract of guarantee to the surety. Why? If the creditor will hide any sort of fact, that will affect the right of the surety in future. Next is form of a contract. So this contract of guarantee can be either oral or written. Next, nature and extent of surety's liability. So the surety's liability is coextensive with that of principal debtor. It is correlated with that of principal debtor. Surety is liable for all the debts payable by the principal debtor to the creditor. Means whatever debt principal debtor is supposed to pay to the creditor, surety holds the same liability. Commencement of surety is liability. So the liability of surety arises immediately on default made by the principal debtor. As and when principal debtor makes a default, the liability of surety will come into picture. A creditor is not required to first sue the principal debtor or first give a notice to the principal debtor. As and when, on the moment when principal debtor made a default, surety's liability will arise. Now, surety's liability may be limited. The surety may fix a liability on the limit on the liability up to which the guarantee shall remain effective. So, over here, what I'm trying to say is that surety in the contract of guarantee can fix the liability. Yes, I will be a guarantor to, I'll give the surety to you, but surety will be limited only to 2 lakh rupees. So in that way, on any amount can be fixed, and this surety's liability can be limited. Surety's liability may be continuous. The surety may agree to become liable for a series of transactions of continuous nature. For example, if A went to a shopkeeper's shop with C and tells the shopkeeper B that give all the things whatever are required by C, and I see that you are paid for a month. So now surety is taking a continuous guarantee for a month. So whatever he will demand from the shopkeeper in that particular month, surety can be held liable. So that guarantee is for a continuous series of transactions which will be done in that particular month. Surety's liability may be conditional. The surety may impose certain conditions in the contract of guarantee. Until those conditions are met, the surety shall not be liable. So there can be any specific guarantee can be made under the contract of guarantee. जब तक वो conditions पूरी नहीं होगी, जब तक वो conditions fulfill नहीं होगी, surety can't be held liable. Next, kinds of guarantee. First one is specific guarantee. A guarantee which extends to a single debt or specific transaction is called a specific guarantee. So as the word indicates, specific. So that is specific to that particular single specific transaction, to a particular transaction only. The liability of surety comes to an end when the guaranteed debt is duly discharged or the promise is duly performed. जैसे ही वो particular transaction खत्म होगा, with the ending of that particular transaction, the specific guarantee will also come to an end. Take an example for that. X guarantees payment to Y of the price of the 5 bag of flour to be delivered by Y to Z and to be paid for it a month. Y delivers 5 bags to Z. Z pays for them. This is a contract of specific guarantee. जो कहाँ तक limited था? सिर्फ उन 5 बैग आटे के डिलीवर होने तक ही लिमिटेड था. Because X intended to guarantee only for the payment of price of the first 5 bags of flour to be delivered at one time. And the same was held under the case K versus Cruz. Second category is continuing guarantee. Continuing guarantee is given under section 129 of Indian Contract Act. A guarantee which extends to a series of transactions is called continuing guarantee. Means this guarantee is not limited to a single transaction. It is limited to a series of transactions. For example, on X recommendation, C employed P for the collection of rent from his tenant. S promised to make good any default made by P. This is the contract of continuing guarantee. जब तक P रेंट कलेक्शन का काम करेगा, एज अ एम्प्लॉय सी के अंडर काम करेगा, till then S is holding the guarantee for P. Next is revocation of continuing guarantee. Now revocation means breaking the continuing guarantee. So how this revocation can be done? So this revocation can be done by serving a notice under section 130 by notice of revocation. Second, by death of the surety under section 131. And lastly, by modes of discharging the surety. So we look at them one by one. So the first category, by notice of revocation under section 130. A continuing guarantee may at any time be revoked by the surety as to the future transactions by notice to the creditor. जब भी चाहे श्योरिटी फ्यूचर ट्रांजैक्शन के लिए क्रेडिटर को नोटिस देकर उस गारंटी को रिवोक कर सकता है. However, the surety remains liable for the past transactions which have already taken place. From the date of notice of revocation के डेट के पहले जो भी transactions हुए हैं, for all those transactions the surety can be made liable. But after the date of notice of revocation, surety won't be having any sort of liability. For example, X gives guarantee to the extent of rupees 60,000 for the loans given from time to time by Y to Z. Y gave a loan of rupees 20,000 to Z. Afterwards, X gives notice of revocation. X is discharged from all liability to Y for any loan granted after the revocation of guarantee. But he is liable to Y for rupees 20,000 on default of Z. Next is Section 131, by death of surety. In the absence of any contract to the contrary, the death of the surety operates as a revocation of a continuing guarantee as to the future transaction taking place after the death of surety. So, death of surety के बाद जो भी transactions future में होते हैं, the surety is not liable for the same. However, the surety's estates remain liable for the past transaction. पहले के means from before the death of sureties, he can be made liable and his estates can also be made liable. But after the death of surety, there is no liability. Now, going forward with the modes of discharging the surety, so we have list of modes. First one is novation, means making of a new contract under section 62. Second is variance in terms of contract under section 133. Next is section 124, release or discharge of principal debtor. Next one is section 135, when the creditor enters into an arrangement with the principal debtor. Next is section 139, creditors act or omission impairing surety's eventual remedy. Last one is section 141, loss of security. So we'll be dealing with all of these in the further slides in detail. Next, going forward, rights of surety. So what are the rights of surety? So now the rights of sureties are against different parties. So let's have a look at them. Right against the principal debtor. So against the principal debtor, surety has two types of right of subrogation and right of indemnity. Right against the creditor. Now against the creditor, again surety has two types of right to securities and right to claims set off. Third, right against co-sureties, he is having one right to claim contribution. So we'll look at these rights in detail now. Right against the principal debtor. First one, section 140, which talks about right to subrogation. On payment of the guaranteed debt or performance of the guaranteed duty, the surety acquires all the right which the creditor had against the principal debtor. So the surety steps into the shoes of the creditor. जैसे ही surety principal debtor का default amount repay कर देता है, उसी टाइम से as and when he makes complete repayment of the amount, then he steps into the shoes of the creditor, means he acquires all the rights which the creditor was having against the principal debtor. Second, section 145, right to indemnity. In every contract of guarantee, there is an implied promise by the principal debtor to indemnify the surety. Means the principal debtor has an implied promise to indemnify whom? To protect whom? The surety. And the surety is entitled to recover from the principal debtor whatever sum he is rightfully paid under the guarantee. Now in this contract of guarantee, if principal debtor will make a default, surety has to make good the loss. He has to make all the payment. But after making the payment, he has all the right to recover that amount from the principal debtor. But not those sums which he had wrongfully paid. He can only recover all the rightfully paid sums. Next, right against the creditor. Under section 141, right to securities. Now, Creditor is having the security. Now, what is security? Security is any kind of property document can also be taken under the ambit of security. Any jewelry can also be taken under the ambit of security. So these security rest with whom? These security are given to the creditor by the principal debtor to take that particular loan. And if the principal debtor is not able to make the payment of that particular loan, then the surety makes the payment. So what about these securities? If the surety is making payment, then the surety will have the right over the security also, because creditor has received his amount. So as and when the creditor receives the amount, his right over the security comes to an end. So surety is entitled to the benefit of every security which the creditor has against the principal debtor at the time when the contract of suretyship is entered into, whether the surety knows of the existence of such security or not. It doesn't matter. It's not a material fact that the surety is already aware about this security or not at the time of making of the contract of suretyship. And if the creditor loses or without the consent of the surety parts with such security, then the surety is discharged to the extent of the value of the security. अगर creditor इस सिक्योरिटी के साथ कहीं भाग जाता है या फिर सिक्योरिटी का कुछ पार्ट कहीं खो देता है, देन जितना पार्ट क्रेडिटर लूज करेगा या जितना पार्ट वो लेकर चला जाता है कहीं, फॉर दैट पार्ट द surety can't be made liable to pay. That part will be deducted from the amount of loan. Next one is right to claim set off. The surety has the right to claim set off or counter claim. Means counter claim का right किसके पास होगा? Surety के पास होगा. Against whom? Against the creditor. Which the principal debtor had against the creditor. जो principal debtor का against the creditor has already secured, उन counter claim के लिए he will have the right. In case the creditor sues him for the payment or liability of the principal debtor. In future, जब भी creditor उसको sue off करता है, he can exercise that particular right. Next, right of contribution against the co-sureties. Now, who are co-surety? Surety is the person who gives the guarantee. And co-surety is more than one sureties. So, meaning of co-surety, when the same debt or duty is guaranteed by two or more persons, such persons are called co-surety. When there are more than two or more persons are there as surety, then they are called co-sureties. Next, rights of contribution against co-sureties. So, first one is right to claim contribution. If a co-surety pays more than his proportionate share of liability, he has the right to claim contribution from the other co-surety or co-sureties. If there are three co-sureties A, B and C, अगर A में सारा जो default amount था वो repay कर दिया, then A has a right to demand the contributory amount from B and C. Next is right to share the security. If a co-surety obtains any security of principal debtor, then other co-surety has a right to share the security. If in the same case, take the example for the same, like A, B and C, all three are co-sureties. Then if A has the possession of the security, then A has to share that particular security with B and C also. Next, effect of release of one surety. Suppose one co-surety has been released from the contract of guarantee. So by this has been discussed under section 138, where there are co-sureties are released by the creditor of one of them does not discharge the other. कोई एक release हो गया, that doesn't mean all other co-sureties has been discharged. Neither does it free the surety so released from his responsibility to the other sureties. Neither that particular co-surety which has been discharged will free him from his responsibility towards the other co-sureties. However, under English law, there is a different criteria. The release of one co-surety shall release all the other co-sureties. Since the liability of co-sureties under English law is only joint and not joint and several. But under the Indian law, it is joint as well as several. Next, going forward with the topic, we have discharge of surety. So, how this surety has been discharged? So, now we will be discussing modes of discharge of surety in details. So there are three categories: by revocation, by conduct of creditor, by invalidation of contract. So let's discuss them one by one. Under section 130, by notice of revocation, a specific guarantee may be revoked by a surety by notice to the creditor if the liability of the surety has not yet occurred. A continuing guarantee may at any time be revoked by the surety as to the future transactions by notice to the creditor. However, the surety remains liable for the past transactions which have already taken place. So from the date of notice, the surety can't be made liable, but before the date of notice, he can be made liable for all the specific guarantee which has been given. Next, section 131, by the death of surety, in the absence of any contract to the contrary, the death of a surety operates as a revocation of a continuing guarantee as to future transaction taking place after the death of surety. Means as and when the surety has died, his liability will come to an end. But before the death of the surety, his estates can be made liable. Means the surety की death होने से पहले जो भी transactions हुए थे, उन ट्रांजेक्शन के लिए श्योरिटी के एस्टेट से लायबिलिटी होल्ड की जा सकती है, बट श्योरिटी के डेथ के बाद फ्यूचर ट्रांजैक्शंस के लिए कोई लायबिलिटी नहीं बनती है. Next is section 62, by novation. A contract of guarantee is said to be discharged by novation when a fresh contract is entered into either between the same parties or between other parties. Now, novation basically means is a new contract or a formation of a new contract. अब वो new contract उन्हीं old parties के बीच में हो रहा है या फिर किसी नई पार्टी के साथ हो रहा है, that hardly matters. The consideration being the mutual discharge of the old contract. The original contract of guarantee comes to an end and the surety under original contract is discharged. जैसे original contract का novation हो जाता है, original contract is converted into a new contract. With the making of a new contract, this surety will be discharged. Next, by conduct of creditor under section 133, by variance in terms of contract, or I should say by changes in the terms of contract. By variance or changes made without the surety's consent, means over here the changes which are made without the consent of the surety in the terms of the contract between the principal debtor and creditor. अब principal debtor और creditor के बीच में जो भी changes हुए हैं और with regard to that change, उन changes की permission surety की consent उनके लिए ली ही नहीं गई है. अगर surety की consent नहीं ली गई है, from that very moment it will discharge the surety as to the transaction subsequent to the variance. Means उन changes के बाद के transaction के लिए surety will be discharged. Next is section 134, by release or discharge of principal debtor. The surety is discharged by any contract between the creditor and the principal debtor by which the principal debtor is released, or by any act or omission of the creditor, the legal consequences of which is the discharge of the principal debtor. Now over here we have two situations under which the surety can be deemed to have been discharged. Situation number one is that contract between the creditor and the principal debtor. अब प्रिंसिपल डेब्टर और क्रेडिटर के बीच में जो कॉन्ट्रैक्ट की टर्म्स है, उन कॉन्ट्रैक्ट की टर्म्स से प्रिंसिपल डेब्टर हैज बीन डिस्चार्ज. अगर प्रिंसिपल डेब्टर डिस्चार्ज हो गया है, then secondary liability will of the surety will also come to an end, so it will discharge the surety also. Or there is any kind of omission by the creditor, means any kind of mistake or any legal formality which is to be done by the creditor and creditor haven't done it. So the legal consequences of that omission will also discharge the principal debtor. So in all, if the principal debtor is discharged, the discharge of the principal debtor will lead to the discharge of surety also. Next one is section 135, by arrangement. A contract between the creditor and the principal debtor by which the creditor makes a composition with or promises to give time to or not to sue the principal debtor. Discharge the surety unless the surety accedes to such contract. Now between principal debtor and the creditor, या तो creditor बिना surety से पूछे principal debtor को ज्यादा time दे दे कि चलो एक महीने में तो लोन नहीं पे कर पाए, hardly matter, you repay me this particular loan within 2 months and that particular surety is not aware about this particular change or arrangement between the creditor and the principal debtor, then the surety will be deemed to have been discharged. Next, cases where surety is discharged, where a contract to give time to the principal debtor is made by the creditor with a third person. And now to give extension of time, this kind of contract has been made with a third person and not with the principal debtor. The surety is not discharged. अगर किसी third person के साथ हुआ, principal debtor के साथ ऐसा contract नहीं हुआ है, तो surety discharge नहीं होगा. Mere forbearance on the part of the creditor to sue the principal debtor or to enforce any other remedy against him does not, in the absence of any provisions that guarantee to the contrary, discharge the surety. Next, when there are co-sureties, the release by the creditor of one of them does not discharge the other. एक co-surety discharge होगा, that doesn't mean the other co-sureties have been discharged. Does it free the sureties or release from its responsibility to the other co-surety? And even the discharged co-sureties also not has been released from his responsibility towards the other co-sureties under section 138. Next is under section 139, by creditors act or omission impairing surety's eventual remedy. Means now what this particular section is talking is, creditor has done any such kind of act or omitted to have done something which has affected surety's coming remedy, eventual remedy, or it has harmed surety's eventual remedy. So if a creditor does any act which is inconsistent with the terms of the contract, with the rights of the surety, or omits to do an act which he was duty bound to do, or duty to the surety required him to do, and the eventual remedy of the surety himself against the principal debtor is thereby impaired, thereby disturbed, the surety is discharged. Next is section 144, loss of security. If the creditor loses or without the consent of the surety parts with security given to him, the surety is discharged from liability to the extent of the value of security. Now security rests with whom? Is with the creditor. Now if the creditor loses that particular security, so the surety will be deemed to have been discharged. Next is by invalidation of contract. Guarantee obtained by misrepresentation under section 142. Any guarantee which has been obtained by means of misrepresentation made by a creditor or with his knowledge and assent concerning a material part of the transaction is invalid. Means some of the fact in the contract of guarantee, means the guarantee has been obtained by the surety and the facts were misrepresented or a part of the facts were misrepresented. So in that particular case, surety will be deemed to have been discharged. Guarantee obtained by concealment means by hiding some particular fact under section 143. Any guarantee which a creditor has obtained by means of keeping silence to material circumstances is invalid. Means he has hidden those particular fact intentionally, or he didn't spoke about those fact. In all, he has tried to conceal those fact. Next is failure of co-surety to join a surety under section 144. Means there was a particular condition that co-surety has to join, then only the surety can be made liable, and they didn't join. Where a person gives a guarantee upon a contract that the creditor shall not act upon it until another person has joined in it as a co-surety. So with this, I have ended the contract of guarantee. Thank you.